Good day everyone, and welcome back to another episode in our What If series, where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. My name is Ross Simon from Maserumule Corporate Employment Law, and in today's episode we will be unpacking what if an employee blames cough mixture for failed alcohol tests. What are the applicable legal considerations and implications? Today we're examining a fascinating case that came before the Labour Court in July 2025, Chill Beverages International vs CCMA and Others. This case presents a scenario that many employers and employees might find themselves grappling with: the intersection of zero tolerance policies and unintended policy violations. Let me set the scene for you. The employee worked as a warehouse controller and forklift driver who had an unblemished service record of 6 years at the time of the incident. On the 20th of May 2023, his career took an unexpected turn when he failed a routine breathalyser test showing detectable levels of alcohol in his system. Now, here's where it gets interesting. The employee didn't deny that alcohol was present in his system, but he claimed something that sounds familiar to many of us. He had consumed cough mixture the night before, and on the morning of his shift, unknowingly ingesting alcohol through this medication. The company had what they call a zero tolerance alcohol, drug and substance abuse policy. The company's stance was clear and uncompromising. Any detectable level of alcohol in an employee's system while at work constituted gross misconduct, warranting dismissal. They argued that this policy was particularly crucial given the high-risk nature of the employee's role. The employee referred his dismissal to the CCMA, where his defense centered on several key arguments. First, he maintained that his consumption of alcohol was entirely inadvertent. He had no knowledge that the cough mixture contained alcohol and had no intention of violating company policy. Second, he argued that despite the presence of alcohol in his system, he was actually not intoxicated and displayed no sign of impairment while at work. Crucially, the employee emphasized his exemplary 6-year service record, positioning this as an isolated incident completely out of character. The employee argued that dismissal was a disproportionate response given the circumstances and lack of actual impairment. The company's position was that policies must be applied consistently and without exception. They contended that allowing exceptions, even for inadvertent consumption, would undermine the integrity of their safety protocols and potentially expose the business to significant risks. The commissioner at the CCMA faced the challenging task of balancing the company's legitimate safety concerns against principles of fairness and proportionality. The commissioner acknowledged the strict terms of the company's zero tolerance policy, but conducted what the law requires: a holistic assessment of the misconduct. Several factors influenced the commissioner's decision. The commissioner found the employee to be credible in his explanation about the inadvertent consumption of alcohol through cough mixture. There was no evidence of actual intoxication or impairment during his work shift. The commissioner also considered the employee's clean disciplinary record and the fact that this appeared to be a genuine mistake rather than deliberate policy violation. Importantly, the commissioner distinguished between the mere presence of detectable alcohol levels and actual impairment that could impose a safety risk. The award noted that even zero tolerance policies must be applied proportionally, taking into account the specific circumstances of each case. The CCMA found the dismissal to be substantively unfair and ordered reinstatement with back pay. The company sought to review the CCMA award. The company argued that the commissioner at the CCMA had misapplied their policy, ignored the inherently dangerous nature of the employee's work, and reached an unreasonable conclusion by failing to uphold their zero tolerance mandate. The Labour Court carefully examined whether the Commissioner's decision fell within acceptable bounds of reasonableness. The Court found that the Commissioner had properly considered all relevant factors and had not misdirected himself in law. The Court noted that the Commissioner's award demonstrated a balanced consideration of the policy's strict terms, the employee's unintentional breach, and the absence of actual risk or impairment. The decision fell squarely within the band of reasonableness. Importantly, the Court rejected the company's argument that the Commissioner had misapplied the policy, finding instead that the award had meticulously addressed both the evidence and the policy's nuances. There was no misdirection or disregard of material evidence that would warrant judicial intervention. This case highlights several important legal principles that apply to workplace disciplinary matters. The first is the concept of proportionality in disciplinary action. South African labour law requires that any disciplinary sanction must be proportionate to the offence committed. Even where an employee has technically violated a policy, dismissal may not always be the appropriate response. The case also demonstrates the importance of the Saduma principle, which established that arbitration awards will only be set aside if they fall outside the band of reasonableness. That means that courts will not interfere with arbitrators' decisions simply because they might have reached a different conclusion, but only where the decision is genuinely unreasonable. Another crucial principle is the distinction between technical policy violations and misconduct that poses actual risk. The law recognizes that context matters and that rigid application of policies without regard to circumstances can sometimes lead to unfair outcomes. Let me leave you with the key takeaways from this important case. First, zero tolerance policies don't automatically justify dismissal in every case. Even strict workplace policies must be applied proportionally, considering the specific circumstances and the employee's intent and conduct. Second, inadvertent policy violations, particularly those involving medication or other innocent consumption, may be treated differently from deliberate breaches. Employers should investigate thoroughly and consider all relevant factors before taking disciplinary decisions. Third, an employee's service record and the absence of actual impairment or risk are significant factors that arbitrators and courts will consider. Context matters in employment law, and rigid application of policies without regard to circumstances can lead to unfair outcomes. Fourth, credibility is crucial in disciplinary proceedings. Employees who are honest about their circumstances and cooperative in investigations are more likely to receive less harsh sanctions. And finally, this case reinforces that the CCMA and Labour Court system provides meaningful protection for employees against disproportionate disciplinary action, while still allowing employers to maintain necessary workplace standards. That brings us to the end of this week's episode. Thank you for joining us. We hope you have found our discussion informative. If you have any questions or comments, we'd love to hear from you. You can find us on social media, or you can email me on ross@massconsulting.co.za. Until next time, bye-bye.